Okay, hopefully those technical issues have been resolved. Mrs. Barrett, can I just check that your connection's now working?
I'm just getting it up now.
Yes, sir. We're just starting the YouTube recording now and making sure that the teams work. The computers in the council crashed, so it wasn't just us; it was everybody. So
oh right, okay.
But seemingly the teams, because that's held elsewhere in the ether, that would have carried on recording even though we'd crashed. So we're not quite sure when exactly we all went out, but we all seem to go out at different stages. But hopefully we should all be back. Yeah, I think we're back.
Excellent, thanks. Well, we're all back. So the last points we discussed were under INSP 5B, paragraph 38, the relevance of changing circumstances since the last hearings in terms of all things employment. I've heard a few things there. One question I had, we've referred to a development consent order which will be put on the examination library. I think I've seen already that a number has been suggested for that. That relates to the M6 junction around junction 12, I believe. And I was asking for clarification, if anyone knows, if that is within Area A, and this is relevant to potential May modification 35, Area A being an area along the M42 corridor defined in the West Midlands Strategic Economic Study.
If I can help, sir, I don't know whether you'd like me to answer that, but as far as I can see, on figure 4.11 on page 44 of the West Midlands Strategic Employment Land Study 2015, the site would fall, as I see it, within the Black Country and Southern Staffordshire area and not Area A. And that might be confirmed by others, but that's where I see it lying.
Okay, thank you very much. Helpful clarification. Mr. Rouse, did you want to, we were sort of on you before the things cut out. Did you want to address that point or raise anything else?
I can completely agree with Ms. Barrett on that point, so that's fine. The only other minor point I was going to make, or small point, was you just asked me about evidence of the lack of need, and just using a couple of minutes we just had, one other reference which I'm sure has been referred to by others in their representations to you, but is the local industrial strategy. And if you were to turn to page 63 of that, where it talks about employment land, that the industrial land strategy refers to the West Midlands Land Commission report of 2017, which again you've heard about many times, which concluded that the shortfall of land for employment space is at least as pressing as the shortage of land for new homes, and possibly more so. And Mr. Best made that point earlier. This is most strongly the case in relation to those large-scale strategic sites that can have the greatest net additional impact on growth and jobs. And it talks about there similarly being a challenge for incubation space as well as grow-on space. And then it concludes that these issues are most severe in Coventry and Warwickshire. But across the region, there is a significant gap in good quality employment land. So the evidence is all there, sir, I think, in terms of there being a shortage.
Thank you. Very clear. That's very helpful. Now, what I'll do is before we move on to MM35, I'll ask Mr. Hodgetts to make any points that he would like. Then I've seen Mr. Lever's hands are up. I'll then get the council to reflect on all the points that we have heard about employment land and the potential changes to circumstances during the examination, and then we'll move on to MM35. So, Mr. Hodgetts.
Hi there. My point was actually just to highlight that Mr. Lever's hand was up, because I believe when you did your whip round of who you'd come to previously, you mentioned his name. So apologies for that. So
Okay.
I'll give him.
Okay, thank you. Mr. Lever.
All right, thank you very much. Most of my points have actually been referred to other parties in terms of changing circumstances, and I'm indebted to Mr. Rouse for that reference on page 63, the West Midlands Industrial Strategy. I was going to make reference to that as well. I've got 3 points here. West Midlands Interchange, that was a Greenbelt site, Greenbelt release, and the examiner's report spent quite a lot of time actually on why the release was justified. One of the reasons that it was justified is that it was a different catchment area to the M42 corridor, and specifically the existing strategic rail freight interchanges at Birch Coppice and at Hams Hall. They considered instead it met a market, essentially the M6 corridor between Birmingham and Manchester. The second point I'd like to make is there was a number of discussions about how the economic position has changed, and I'll just add one thing. No one's actually mentioned, and I endorse everyone what has said, things have changed a great deal, and this has actually resulted in a lot more take-up, and looking forward to actually some stronger market drivers. Obviously reference is made to e-commerce, but no reference has been made to the uncertainty about Brexit and some of the implications that may have going forward. And one of the things that JLL and other agents consider will change is that there'll be much more significant amounts of reshoring. Essentially, because supply chains are not as robust, or there cannot be so much certainty, manufacturers particularly, but also others, logistic operators and retailers, are holding significantly greater amounts of inventory or product, and that is leading to an increase in demand and floor space. Ernst Young, or EY as they're now called, made reference to this in their most recent UK attractiveness survey. This was published in November. And they cited that 32% of manufacturers that they had spoken to were planning to increase their reshoring activity. I've got one final point, and that's one final point about supply, and particularly pertaining to supply, how it's changed in North Warwickshire over the last few years. I don't want to introduce too many figures, but I'll try and make these as simple as possible. There seems to be a consensus that the amount of take-up in the borough is about 20 hectares per annum. That's judging from what people have been saying, including Mr. Best, but also in just terms of the data that has been produced by both Savills and the Borough Council. The vast majority of that is for what I refer to as big box or big B8, and it's been at Birch Coppice, Hams Hall, JLR's facility at Baddesley, Tamworth Logistics Parks. I believe, or looking at the figures in terms of the supply, I think there is less than 30 hectares of suitable land for large-scale logistics, that being existing land or remaining land at Core 42, Tamworth Logistics Park, Hams Hall, and proposal E2. But just for the sake of argument, I reckon that's 28.7 hectares. But if you just to make the maths simple, if you have it as 30 hectares, so you have a supply of 30 hectares, you have a trend or demand running at about 20 hectares per annum for this type of product. That means that you have only 1.5 years supply left at the current rate of take-up or development.
Okay, thank you.
Were those figures clear?
Yep, I can see them, and I believe there was some discussion in the previous session about what at that point the West Midlands Strategic Economic Study pointed to in terms of supply relative to demand at that point in time, which is not, as I recall, wholly incomparable with that figure that you've just given, but at a broader level than a borough. So thank you very much. That's all very clear. Now, if I can ask before we move on to MM35 for the council's comments insofar as they would like to make them on any changing circumstances. We've heard some points around the planning practice guidance, around trends in demand and supply for employment land and specific types, namely logistics. So any comments that the council would like to make in that respect?
I don't want to repeat what we've already said in the previous matter hearing, sir, so I'd refer you back to our comments that we made at that stage, because and in terms of the situation, I think everybody has been able to say that there is still the demand, but nobody has been able to tell me how much land it is that we need to allocate. So it is that is still missing in this equation. And so I don't see that really the situation has changed. Yes, there's different forces, Brexit, COVID, and everything else. So the Borough Council is aware of the issues, but nobody's been able to quantify and say you need to allocate, or we need a site of X. So I think that's where we're coming from at the moment. So,
okay, thank you. Well, that's all. I mean, I think I've heard everything I need to there. I've certainly got a lot of evidence to look through with a strong cup of coffee. So that's all very helpful. I would mention I'm not directing you, Mr. Lever, to turn your camera off, but I would just I would just note that it's on, just in case, just so you knew. Right, then let's turn to and let's deal with them collectively. I would like to break around one. I think that's probably doable. Let's all turn to paragraphs 39 and 40. Let's deal with them collectively. Of INSP 5B, which deal with MM35, which has been suggested, and it seems from what I have just heard, like the council are in principle agreed to that on the basis that there is some, albeit unquantified, evidence of significant need for employment land in the broader area, but I note the points they make about geographic specificity and the quantity. But it seems like the council supports or would support that main modification in the event that I find it to be necessary for soundness. You can correct me on that point if I'm wrong, but if I can just take the points as I have them that people have made in respect of potential MM35, and these are all coming through the additional local plan consultation. The first point is the version I have says there was a point raised, sorry, by possibly Stoford, Mr. Best, regarding potentially a previous iteration. No, sorry, I'm wrong. This is some very intricate points here, but there are two different requirements, and this is potentially relevant to what Mr. Best would say. I'll take that point first. As it is currently drafted, potential MM35 looks at significant weight to start with, and then before the bullet points says proposals supporting economic growth and productivity in that context will be looked upon favourably. I think the point raised by Mr. Best was that those two phrases should be the same and significant weight used. Is that correct, Mr. Best?
Thank you, sir. yeah, you picked up on a point that I wasn't necessarily going to make.
I'm terribly sorry if I have.
Yeah, I know that there were. I just wondered whether in your introduction there you were confusing. I mean, Stoford in their representations did make a point where they compared and contrasted the suggestion they'd originally made, which I think was Mr. Sitcher's drafting, or certainly it was in representations they made. Stoford had then made a representation in October, which does a comparison between the council's version and their version. I've then put forward an alternative version in our representations, and obviously we hadn't seen each other's at that point. Okay. And we can perhaps get on to talk about that. But I mean, I don't feel the need to make any further points unless Mr. Sitch wants to come in at that point.
Thank you for clarifying that. Mr. Sitch, did you want to?
Yes, thank you, sir. I was letting you obviously ask the question just to be clear, but
I think that's charitable. You were letting me tie myself in knots.
Well, I'll jump in next time. Maybe there won't be a next time, of course. You and Mr. Best are right. The MM35 originated at the first hearings and was submitted to the inquiry in the August. Or our statement of common ground, as it was then, is dated 31st of August 2018, which has the, if you like, the original version of MM35, and the representations that we submitted, Stoford submitted in October 2020, did a comparison exercise between that version for the first hearings and the version the council have now put forward, or the version we have at the moment, which is MM35, which is on page 17 of the main modifications, which is NWBC 20E, and it was very much the point you said. It was the latter situation in terms of the wording, and how that worked in practice. And your question 40 picks up the point about effectiveness and the interrelationship to other policies. But in terms of the wording itself, yes, would agree with the, your latter point in terms of significant weight and look favourably upon. And then it does lead on to the second question, which is around related to other policies. But
yeah. So let's deal with that now while you're on the line. I mean, as I have it, the issue is around two policies in particular. One being the approach to the greenbelt, and the second one being the approach to the settlement hierarchy.
Indeed.
And
yes.
As I understand it, the argument being put is that additional employment land may, sort of by virtue of what it is, come forward in a location which is not in line with the settlement strategy, and that's okay because it responds to the particular requirements of employment land. So on that point, potentially the interaction of MM35 with policy LP2 needs to be clarified, as I see it.
Yes, that's correct.
So thank you. I can see that point. The interaction with greenbelt policy, and I'm just is that LP3?
That is LP3, yes.
Has been a bit of a subject of discussion in the previous session, and are you then advocating that there is something to say will be accorded significant weight, including in applying greenbelt policy, that sort of thing?
It is that sort of thing, sir. Yes, I think that the policy needs to be framed positively. We say it needs to be more locationally specific, and you have our wording of last year, and that's been taken on again by Mr. Best and others, and we can settle on a preferred wording if that's helpful to you. We're already exchanging that emails on that, but by not dealing with greenbelt, I think we're ignoring the need that we're talking about. We are talking about strategic employment. We're not talking about local. We're talking about strategic employment, strategic warehousing, logistics, and we know whether it's the current MPPF 2019 or the PPG references, or to some extent the MPPF 2012, that the locational characteristics of that strategic warehousing is very much tied to the strategic road network, be that the motorway network in this case, and also the trunk road, picking up the A5 point that was raised at the previous hearings by Mr. Hodgetts, which goes to Area A, and that's why Area A is the area of greatest demand or need, is because of that highway network. We also need those locational characteristics in terms of being linked to strategic rail freight interchange, and we know that we have that in Area A as well. So inevitably, those routes, those strategic road networks, rail, etc., are within the green belt, and therefore there needs to be recognition in the policy, MM35, to that situation. It doesn't remove the need or the test of green belts. The wording you have from both myself and Mr. Best deals with the need to demonstrate, in this case, very special circumstances, because it would be a planning application. But it recognises that is the type of employment need that this plan's looking to address, or may need to address in the future. And I think to separate the two, they're not talking to each other, and I think we're then, there's a direct conflict between MM35 and LP3. Before we start.
Thank you. Now let me on those 3 points actually. So the looked favourably upon phrasing as opposed to significant weight, the interaction with policy LP2 and the interaction with policy LP3. Let me put those points to the council specifically for effectiveness, and with regard to NPPF 2012 paragraph 154, which guides that policies should provide a clear indication as how to a decision taker should take a decision. Does the council feel that for soundness some clarity would be required? Would be required in that respect?
It is my opinion, sir, that the local plan should be read as a whole. So I'm struggling to see that if you've got the national green belt and the policy then refers to that special circumstances still need to be demonstrated, isn't that what LP3 and the MPPF already says? So you're duplicating what effect is the green belt policy. So and I can see that when you look at Area A, the vast majority of that is in the green belt. But surely the two policies should be read together then. So
I see your point. That from your perspective, so we'll come on to that. But I presume, given that significant weight, and taking one step back, I presume you accept that if I find that there is evidence, as it seems you acknowledge that there is evidence of if I can call it sort of broader than borough-specific demand for employment space, that main modification 35 would be necessary for soundness. If that is my view, that MM35 is necessary for soundness. The second point is, I presume you have no objection to the use of significant weight in the start of it. Is that right? I don't want to.
Yes, that's right. So because that would that language is very similar to that given to the green belt anyway, but it also shows the importance as well.
Okay. Yeah. No. I see that. So then I presume looked favourably on was not consciously trying to be a different test to that significant weight. It was just a sort of an alternative way of phrasing it. That looked favourably upon as in the final sentence of the body text. Proposals supporting economic growth and productivity will be looked favourably upon. That might equally say will be accorded significant weight provided that there is provided that criteria 1, 2 and 3 are met.
Yes, so when you read the whole of the policy as it's written, already at the start we have significant weight will be given in decision taking to supporting economic growth and productivity. So the repeat of that last sentence probably we don't need, because it actually does repeat, and you're adding in different wording, which I think is not good. So it would be subject to the following criteria. Okay.
Well, that's that's some movement. I put that on my list of things. What I've heard from you, and again, tell me if this is incorrect in my understanding, but that because what MM35 would be to accord significant weight, there's no need specifically to clarify that in terms of the interaction with LP3 Greenbelt policy, given that the significant weight under policy LP6A would be taken into account in the council's consideration of anything that did come forward in the Greenbelt.
Yes, sir, because everything's weighted and balanced against each other, so it would be in the final planning balance. So
okay. And the last point, if I may, which was about LP2, do you accept Mr. Sitch's point that you may under MM35 get proposals for employment uses that come forward which are not in line with the settlement hierarchy under policy LP2, but which are nevertheless acceptable provided they meet the criteria of access to the strategic highway network, reasonably accessible and otherwise acceptable? Or do you differ on that point?
No, I think there could be, but again, it's the balance and weight that you would give to the policies in terms of that decision making. So we're already saying that significant weight will be given to the fact that it's for employment use. So that in itself goes against the plus side, and then we'd have to weigh up all the other issues, because I do think that there are issues there that you can't just assume that we've got the overall development strategy, which we believe is the best one that we've got, but as with everything, there may be odd things that come up. And so what we're trying to do here is trying to get a solution for something that we're not quite sure what the answer is. And so I don't see that we should alter LP2 to reflect the fact that, oh, but by the way, we might allow this, because surely that's in the planning balance in the round of when you deal with a planning application.
Thank you. Okay, let me, and I should just remind myself as much as anyone else that what I'm thinking about is soundness, and those parameters in paragraph 182 of the MPPF are fairly clear, and to that end, I just need to be careful what I do in terms of focusing on soundness as opposed to the precision of wording where that is not a matter of soundness, or where the interaction of policy is not a matter of soundness. So that's just something I'm reflecting on in the background. But let me hear from Mr. Sitch again on those points, specifically that the plan must be read as a whole, and therefore the council's view there's no particular need to clarify the Greenbelt interaction, or indeed policy LP2, and then I'll go to Mr. Han. So, Mr. Sitch.
Yes, thank you, sir. I mean, your question obviously is well made in the sense that we're dealing with one policy, but we've already raised, your question actually refers to LP11 as well, which I was going to refer to, which is actually in the main modifications as MM49, but LP11 deals with economic regeneration, and the in the context of MM49, you'll see, so it refers to proposals for new development and redevelopment of existing employment land outside development boundaries, which picks up your LP2 point, will be considered against policies LP1, LP2, and should retain rural character, appearance, and openness to the countryside, including in respect of policy LP3 Greenbelt. I think it's important to provide certainty for those looking at the plan, those reading the plan, and you can say reading the plan as a whole. And that certainty is for the council. The certainty is for landowners, developers, promoters, and certainty for communities. And I think there is a need to include reference in terms, or cross-reference particularly the Greenbelt point and the inclusion of Greenbelt within the policy, because that provides certainty. There is no doubt, and as Ms Barrett's confirmed, Area A is predominantly in the Greenbelt. It's no coincidence, but that is where the strategic road network is, and that is where the greatest need is, because that's the locational characteristics of the need that we're talking about. So I understand your point in terms of soundness and in terms of the policy, but we think that actually to make the policy sound, or its inclusion, is needed. But we also think that in terms of wording, we should deal with LP2, LP3, and LP11.
Okay.
Which is what we sought to do in the form that we've put to you, and there's further iterations of that, which we're happy to agree with others.
Thank you. Well, I think that's very helpful, and I've certainly heard the two sides, and I will have a little think. I mean, I think probably what I'm going to put on my list of actions, which will be no surprise, is for the council to have a reflect on MM35. The technical point we've alighted on, which is the last sentence, and looked favourably upon the distinction between significant weight. I'm just going to hear from some other people before I kind of take a view as to what consideration should be given to other policies. So let me hear, as I said, thank you, Mr. Sitch. Let me hear from Mr. Han.
Thank you, sir. I think in looking at the policy, I think our starting point is that we touched this morning a little earlier on the importance of having a criterion-based policy and understanding the weighting to which the policy will be put in conjunction with applying it with other policies of the plan. And I think our concern, as I know from others around the virtual table, was around just internal tensions between effectively the policy giving a significant weight, but then leading you down the rabbit hole of another policy. I think our key issue surrounds probably the issue of a policy which you hadn't referred to in your question, which is SL5, LP5, which is the meaningful strategic gap. Because I think that area A, as we've touched on earlier, covers an area to the east of the conurbation, but it includes not only Greenbelt but also strategic or meaningful gap and land outside of that. And I think it's a really important consideration, because the meaningful strategic gap covers land around Junction 10, which is clearly in the corridor, in the main corridor of interest in that zone. And our view is that in terms of looking at application of that policy, the meaningful gap or strategic gap is a local plan designation, whereas Greenbelt clearly is a national designation with clear rules and requirements set out through MPPF. And the view we have is that for the policy to provide some clarity, it needs to not have an internal tension with LP5, or for it to expressly provide some primacy over LP5 where a need is demonstrated, in order for it to have some teeth and to bite, such that were a strategic need to be identified, that it would be clear within the policy that it would have some primacy over LP5 and the application of that strategic gap. And I think it's a similar point to that which Mr. Sitch has raised with regards to Greenbelt. So if we're having the discussion around reference to Greenbelt, our view is we need to have on the table at the same time LP5, but we see LP5 as a sort of sequentially preferable point because it's not in the green belt, and therefore the level of protection to that area is less so, and it's something which is governed by the local plan itself, as opposed to wider tests set out through national policy. So, with respect to the green belt point, I think unless I'm misquoting what Mr. Sitch is suggesting, he's suggesting it indicates that leads you to inappropriate development, leads you to a set of tests which are well known and understood. So it just it leads you in that direction. But I think from our point of view, the strategic gap point is different to that insofar as it's a locally derived designation, where if LP6A is to have some teeth, there has to be some express that significant weight will be put over it. And it's that interrelationship with LP5 that doesn't lead you down the rabbit hole I touched on earlier. I think that's our key point to get across here. I know it's something which just wasn't in your question, so
okay, no, that's yeah, no, that's a fair point. But can I just ask in that vein, and I see, yes, we're kind of amassing a number of policies where there's a potential interaction, and I understand, I understand the point in terms of clarity. I think what I will have to take a view on is how far that clarity is intrinsic to soundness of the plan, and how far that will inevitably have to be more for a decision-taking role. But just in terms of the points you've made, do you have any objection to the use of Area A in the West Midlands Strategic Employment Site study?
No, I think from our perspective, it's a study which has been prepared. It's been discussed. It's an evidence-based document before you and the examination, and it provides that geographical area. There is some precision. It's a key area which has fallen out of empirical evidence and research. So, from our point of view, we're fully happy with Area A being, clear and fairly precise in terms of identifying the area, and that links back to the paragraphs we quoted earlier from MPF around the policy. So, no, we're fully happy with that.
Thank you very much. Okay. What I'll do now then is I'll hear from Mr. Best again, and then Mr. Rouse, and then we'll come back to the council. So, Mr. Best, please.
Yeah, thank you, sir. Just picking up a point that was made earlier on how the policy interacts with Greenbelt, and I think it was a point that Mr. Sitch made, and then Miss Barrett came back about duplication and significant weight on one side and clearly very special circumstances on the other. We know how high a bar very special circumstances is, and in fact there have been several decisions in the Northwest recently on large logistics schemes in the Greenbelt, even on draft allocated sites, which have been rejected by the Secretary of State. So we know that very special circumstances with regards to logistics during 2020 is still an exceptionally high bar. So our concern clearly is if we accept, sorry, is there any interference or delay? I'm just getting you frozen slightly.
I can see and hear you clearly. Sorry if I'm
fine. Okay, I just wanted to check that I wasn't talking to myself.
Thank you. Yeah.
So yes, I think what we're concerned about is that in our case at this examination is that the plan should determine the need and allocate sites accordingly, but we are prepared to support MM35 if you feel that it is the alternative way of making the plan sound. So that's our starting point. So once we then get into MM35 and to what extent is that sound, we obviously are talking about how the policy works, what its criteria are, and I like Mr. Hand's reference to rabbit holes, because I think we've got a rabbit warren potentially here to try and deal with, and I appreciate that makes it that much harder to get the policy right. But I wanted to make one specific point with regards to this how do you deal with a green belt in applying this policy? Because right at the top of this morning, I was taken to mm61, which is part of policy LP 27, and I was told that passage, which states, and I'll quote very briefly from it, but it's mm61 just for clarity. The Borough Council supports, in principle, proposals for the replacement of lawful building structures and uses, including those with permission if their demolition or removal is required by HS2, or their ability to continue to operate as such would be compromised, and then particular regard will be had to the aim of relocation, etc., etc. I won't quote it all, but my point is that was referred to me as being a pretty cast iron guarantee that I could replace a planning permission on the Coleshill Manor site elsewhere within the Greenbelt. My point was, well, Greenbelt tests in very special circumstances would have to be applied to any proposal. And so I don't think I could rely on MM61 to give me the absolute confidence that I would take that use anywhere in the Greenbelt. And I think you went on to say something like, do you think it would give you the confidence that you could have 16.83 hectares, 16.38 hectares worth of replacement land? And my point M61 has to be read in the context of Greenbelt policy. So if what you're trying to replace is in the Greenbelt, it still has to test of green very special circumstances and the weight that then is attached to those. And the same is true here, that I think if the policy isn't clear enough to say that if there's a significant evidence of need for large-scale development, and if that development was to be in the Greenbelt, then it would need very significant weight to overcome the likely Greenbelt harm. And I think that needs the maximum amount of policy, which is why our suggested wording probably goes further than others in providing what I think is a robust policy that can be read in right and clearly has, and I concur with Mr. Sitch that there may be some tidying up of that so that appropriate references are made. Bear in mind there's no offer here of explanatory text, so we could perhaps think about how the supporting texts to such a policy would make those appropriate cross-references so that the policy can be read in itself, and as you know, it's often useful in supporting text for those most likely and relevant cross-references to be drawn to your attention in the reading on the face of the policy itself. But my point is, yes, that the Greenbelt, I think, has to be dealt with in the policy so that it's clear to what extent that significant weight is going to count in the balance. And I'll just pick up one other point, which is that Miss Barrett said that, you know, policies such as this need to be perhaps in the plan to deal with odd things that come up. And I just don't accept that this is an odd thing that might come up. This is something we've known about since the last inspector determined at the last core strategy examination that strategic needs would need to be dealt with in this local plan review. And I accept that they haven't been for good reason, or perhaps not a good reason, but for reasons that we all accept. So they're not odd things that come up. These are things that we know about, and it goes back to the MPPF para 161 about all foreseeable economic activity. So I think this policy at its minimum has got to do enough to demonstrate the plan is anticipating what it knows is foreseeable economic activity that is likely to come forward, and deal with it accordingly. Because what I think the failure of MM35 is if in 5 time viewed, no permissions have been granted under this policy, despite the overwhelming market evidence that sites should be coming forward.
Okay, thank you. I did hear all that. There was a bit of a lag, so perhaps that was why I wasn't particularly responsive. But
right, sorry. Where did you lose?
No, I heard it all, but in segments. So yes, I got it all, but there was a little bit of a lag on the line. So thank you. Okay, no, I think those are points well made. What I will do now is turn to Mr. Rouse, and probably what I would ask the council to have a look at is Following that, and not preempting what Mr. Rouse may or may not say, but is to look at some way of clarifying how potential new policy LP6A interact with the following policies: LP2, LP3, LP5. And was there another one? LP, there was. LP11. Yeah. So that may be a sort of simple statement saying that the significant weight will be balanced against other policy objectives of those policies in arriving at a decision. It may deal with them slightly separately, seeing as they deal with slightly separate things. And it may be, for example, there is the criteria there under policy LP6A via potential MM35 related to access and location have a slightly different relationship to policy LP2 in terms of hierarchy of locations. So it may deal with them differentially, or it may be, as Mr. Best was suggesting, that the council's view is the best way to deal with that is to put it in a sort of reasoned justification or explanation. I would like to see what the council propose in that respect. Ideally, when we come to paragraph 59 on Thursday morning. I think that's as far as we can go at this stage. That's as far as I'm confident at going, because I will have to reflect on two things: the relevance to soundness, and secondly, the what can be done, or what is it legitimate to do in terms of a local plan and soundness versus what inevitably relies on decision taking. So I'll put that marker down, and now I'll turn to Mr. Rouse.
Thank you, sir. You've slightly pulled the rug from beneath my feet there, but that's
sorry.
That's fine. I think that covers what we wanted to get to, doesn't it? But very, very quickly, just so you're clear of our position, I set out Prologis' position in my representation in relation to this matter to LP2 and LP3, i.e. that I'm very firmly of the opinion there is conflict or potential for ambiguity and that needs to be addressed directly. I would add to that, having reflected on the discussions we've just had from others, that LP11 is relevant to that, and in certain situations I can see that LP5 would be too. In terms of your dilemma, sir, in paragraph 182 and your job to consider consistency with national policy, to my mind it is clear, and I think I referred to this earlier in terms of the need for, I've lost the reference now, which is typical. Oh yes, paragraph 154, clear policies on what will or will not be permitted and where. And I think therefore removing ambiguity, if Ms. Barrett accepts, as she has said, that you read the plan as a whole and therefore you would regard LP6A as being the superior policy in those circumstances where LP6A is triggered, then I can't see any harm in making that explicit in the policy itself. If it avoids ambiguity and uncertainty, and the fact that a different person may in a few years' time pick up that plan that hasn't been party to this examination, it would help everyone concerned. So I can't see any drawback from being clear. And to further that point, we've probably all been caught in a situation where we've been, reminded that supporting text is not part of the policy. It's not part of the development plan to which the decision should be taken. And therefore, it's important to my mind that clarification is within the policy itself.
Okay.
Please. So that's all I wanted to say, which simply reinforces what you've just said.
And I think on that point, you're potentially referring to, I forget the name of it, but some recent case law that came out. Okay. So Mr. Best, was there anything? Thank you very much, Mr. Rouse. And Mr. Best, was there anything you wanted to add to that, or shall I put that now to the council?
No, that's fine. Thanks.
Okay. Thank you. So, Mrs. Barrett, are you content to have a look about, and I'm not saying how that interaction should work, but some form of explanation for NPPF 2012 paragraph 182 effectiveness, so that it is clear how policy LP6A via MM35 interrelates with policies LP2, LP3, LP11 and LP5. That's not to suggest there's any hierarchy, but it's to clarify how that significant weight would relate to those other policies. Are you okay to have a look at that and come back to us when we get to, I think it's paragraph 59 of INSP 5B at the start of Thursday?
Yes, sir. We'll try and aim for that.
Okay, thank you. I think that's about as far as we can take it. And clearly, any schedule of main modifications will be the subject of further consultation. But Mr. Hodgetts, you have your hand up.
Thank you, sir. A couple of things I just wanted to pick up, and appreciate that you were trying to summarise there and bring discussions to a conclusion. So I'll be brief if I can. Wholeheartedly concur, obviously, with the points of Mr. Han in relation to LP5, and welcome the fact that you've invited the council to go in and consider how that would the interplay of that with LP6A. I agree with the further points of Mr. Han that reason justification, if there's text in that form, could help to clarify that. Second point I'd like to make of 3 points is a kind of real life example of the current decision that Mr. Dittman referred to earlier. He referred to 2 decisions in the Greenbelt that have been made recently, that being the continuous wall of prayer and the what is, I believe, to be called Surf Park, both near Coles Hill Manor. In relation to the continuous wall of prayer, I can actually give you the application reference number if that would help. But in relation to the officer's report on that decision, which at page 4, in its second paragraph, concluded that the development was inappropriate development in the Greenbelt. The exact wording is: the consequence of this, and it's considered that the proposals do not satisfy the 2 conditions. As such, the proposal is considered to be inappropriate development in the Greenbelt. I just wanted to highlight a real world example, because at the moment we're talking very much hypothetically in the future and tensions between policies. There's a real world example of how, with the current development plan in practice, a decision maker has successfully been able to weigh up the tension of Greenbelt policy, nationally designated Greenbelt policy, and its continuation of similar policies in the core strategy and emerging local plan, LP3 most notably, and the what must have been need or exceptional circumstances to justify approving the continual wall of prayer in the Greenbelt. There's an example of how, if in a similar scenario were the need for strategic employment demonstrated to be so acute that it would pass the exceptions test, and then plainly a decision maker is able to come to that decision without having to have a policy, LP6A, which specifically refers to it. And apologies, I've actually forgotten what my third point. Oh no, I've remembered it now. Sorry. And I feel that I don't want to kind of get into too much combative kind of form here, but I note the various people obviously put forward various iterations of LP6A in response to the council's version in in the proposed MM's document. One of the points highlighted by Turley in their suggested version is that any proposal should demonstrate that there are no suitable, available, viable alternatives to meet allocations outside of the district. I have my particular kind of issues with that, because it's almost like you're establishing a need and then saying you should look elsewhere to where it should go. So I think there's difficulty there, but the point that I'm speaking to right now is in relation to Greenbelt, and it's, if you're saying there should be a need to look elsewhere outside of the borough, then surely if you're saying that there's sites that should be allocated, or you're appointing a decision maker to give significant weight to a decision of a site in the Greenbelt, surely there should be some kind of further referral process where they should first look at the sites outside of said Greenbelt within the borough prior to coming to that conclusion as well.
Okay, thank you. That's very clear. Any comments, Mrs. Barrett, on those points?
No, I don't think so, sir, at the moment. Thank you.
Okay, thank you very much. And I've heard that's very helpful, everyone. I've heard what I need to. I've put that as an action for some clarity on interaction for the purposes of effectiveness. We've heard from various people on that, so I think I will call that element there. And clearly, I'm just looking through my notes. I have got various, Mr. Hodgetts in particular referred to various different forms that MM35 has been suggested in, so I will consider those. I saw a hand flick up, and which has gone down, so I will proceed onwards. No, Mr. Rouse, your hand's gone up.
Sorry, sir. Apologies for up and down. It was just a very quick point in case you wanted a case reference for the issue about policy. You mentioned possibly a case there when I made that point. I'm sure there's probably more than one, but one that is relevant is Crown on the application of Cherkley campaign versus Mole Valley District Council in 2014, which made the point that a requirement placed in supporting text couldn't be termed part of the policy.
Okay, thank you. Yes, and I think there's no need particularly to reflect that in the examination library. I think that's sort of planning knowledge, if I can call it that. But no, thank you for that. That's very
thank you.
That's very good. Okay. So on to paragraph 41 of INSP 5B. I have put some people down against that point, which is whether a commitment to review the plan in the event that circumstances change. Mr. Rouse, you've got your hand up. Is that a new point, or? Oh, okay. I'll assume not. My question was, is where so should, first of all, a review be within a policy itself? And I've asked the council to reflect on that and to come back on Thursday morning on that. I'm not convinced yet either way, but I would welcome hearing the council's views based on our discussion yesterday when we touched on that. The second element of that paragraph, as drafted, is MM7 sufficiently specific to the trigger that would require an early review? Now, would anyone like to speak to that point? Again, I think this is something that we discussed yesterday in the context, albeit in the context of housing, where there was some discussion about whether that trigger should kick in where certain metrics are met, say where supply falls below a certain level. It's obviously different in the context of employment land, but would anyone like to speak to that point in terms of employment land? If not, we will return to that matter on Thursday morning.
Excuse me, sir.
Yeah.
Yeah, can I just ask?
Sure.
Would we then be talking about, because Turley's have suggested a policy LPX on their ALP 43, page 9, a local plan review policy? Is that where you'd like that discussion to happen as well?
Yeah, as I remember it from our discussion yesterday. No, not as I remember it. I would like I would like some consideration to be given to the council as to whether that needs to be articulated, as to whether a commitment to a review needs to be articulated in terms of a policy, or whether you are satisfied that that can just be as it exists in the plan. In terms of whether that needs to take account of certain metrics, yes, consider that. Does it need to reflect that point of Turley? I'm not sure I'm quite there with you on that one. Maybe could you just go through that again?
Well, it was just in case, sir, that you were thinking, if you were going down the route of thinking that you like the wording from the Turley's suggested wording, because that focuses on the employment side of the review, and it was just whether it was I suppose that if you were going to have that as a review policy, that essentially is LP 6A, so it would, right. And so I was unsure about whether that would, if a review is coming forward because of new evidence, does that mean that you have to have 6A, or is it that we're having 6A, but we've got the metrics in MM7 to say about the review? I'm probably not making myself very clear, but I see it's just that interaction between them all.
Yeah, as I saw it, the two are separate things. So the commitment to an early review in the eventuality that circumstances change is a broad commitment. Now, since we have been in examination, there has been a legislative requirement that plans are reviewed every 5 years. So I have to say, as an indicative view, I'm not necessarily convinced that that needs to be in the form of a policy. That said, yesterday, in terms of early review, we discussed that the council would look at some of the other examples that have been out there of policies and see whether and how that marries up with early review. But I saw that as a separate issue to the MM35 and the potential new policy LP6A, which is looking at monitoring on a continuous basis rather than, say, triggering a review of the plan. What that is triggering a particular approach to taking a decision in the eventuality those criteria are met. So one's to do with plan review and one's to do with decisions. So that's how I saw the interaction.
Oh, that's perfect, sir.
Okay.
That's fine. I just wanted to make sure that I wasn't getting myself muddled up between all the different parts here.
No, sure. And when we come to your consideration of early or local plan review on the morning of Thursday, there was some discussion yesterday about what triggers, what would trigger and at what time that review would be triggered. And I think it would be useful also in that frame to consider what triggers might be there in terms of employment land. Now, that may be actually, then it refers back to monitoring indicators, which we're going to come on to under paragraph 44 in terms of employment land provision. Say if there's continual provision of employment land in line with new policy LP6 outstripping what was forecast, that may be a relevant indicator that actually feeds into a review. So I think hopefully that clarifies where I'm coming at things from. Now, I've seen some hands shoot up. I do want to deal with monitoring under paragraph 44 and probably relatively briefly with paragraphs 42 and 43 of INSP 5B. So could I ask, as I'm sure you would do anyway, but I'll go to Mr. Sitch, Mr. Best and Mr. Rouse in that order. And please, if I can ask you to keep your comments relatively succinct, that would be great. Mr. Sitch.
Thank you, sir. Very much in line with your point about being succinct. I left yesterday on the basis that Ms. Barrow had agreed to a local plan review going into policy, and that was something that Ms. Barrett and Mr. Dittman were going to consider. I think in the context of employment and MM35, I think it's essential there is a local plan review provision ahead of the 5 years review, which and the trigger for that, so it could be partial review, but the trigger for that would be in respect of the West Midlands Strategic Employment Site Study version 2 publication, because of what we all know that's in there, but we can't refer you to it.
Thank you. And that was very tactfully put. And I think in terms of the first point, what I heard on local plan review is that the commitment is there from the council in the plan. It's the mechanism that is potentially at issue. So, and that's what we're going to discuss when we come to it on Thursday morning. In the meantime, the council are going to reflect on that. So that's a helpful point in terms of MM35 as well. Thank you very much. I think I mentioned Mr. Best now.
Thank you, sir. Yeah, picking up on the point that Mr. Sitch has just made, I think it's the interaction really of MM35 and MM7 that I'm concerned with. And a point I made earlier was that clearly if there's evidence of a need that needs to be addressed through the development management process, then MM35 is about allowing a proposal through the gate of MM35 if it meets certain tests. But the point is that if that study is identifying a scale of need which needs duty to cooperate agreements to be in place, then that needs to be done through the local plan process. And I think therefore my point earlier was that what I see as MM7's trigger is possibly more so the policy mechanism. And I suspect that's going to be further down the line. So, you know, I'm kind of arguing against myself here, but I think the reality is if MM35 allows for a need to be met that can be proven, that MM35 does its job, and then MM7 is triggering the local plan review once we know what the policy response is going to be, because my fear is that the study itself is not going to give us the answer. So as upon the point that that's published, if it's on January the 2nd, I'm not sure a local plan review could have been very easily started at that point, and Miss Barrow would probably say, well, I still don't know what to do with it. So I think that sort of the policy mechanism has got to be incentivized in some way and delivered through you know, whatever follow-on work is needed after the study is published, unless it dramatically produces a policy mechanism that isn't in the current draft that we've seen and that we know that you haven't.
Okay.
But I think that's where I think the trigger point perhaps is a slight distinction. I wasn't at yesterday afternoon session, so I don't know the extent of the discussion about the review mechanism, but certainly the policy that we had in mind was there to assist with how to deal with its employment land point, particularly in relation to MM35.
Thank you. Sorry, I was just writing down a few. I think it was very clear. Thank you. Mr. Rouse, and then I'll come back to the council. I've got one point I want to raise based on that. Mr. Rouse.
Thank you, sir. I'll be quick. It was just really to reinforce what you were saying in terms of distinction and the need for both MM35 and the review policy. At the moment, as drafted, MM35 is a response to immediate need. And I think we'll have to touch on Thursday as to what we actually mean by that. But taking it in kind of general sense, if the need is there now, even going through a planning application process is a long-winded business and can take too long. The statistics I referred to earlier in my representation, in terms of the 3/4 of this take up nationally is in new buildings. Well, 20% of that 20% of the overall take up of all take up. So a significant proportion of new build take up is of speculatively built buildings, and the reason they are speculatively built is because you have to respond to an occupier requirement that can't wait for a planning application process and then site infrastructure and then development of a building, because that takes years. So if the policy is one that's targeted at dealing with an immediate need, then it needs to be one which is very permissive, very clear, and allows for development to happen. And that is different from what you say the MM7 is intended to deal with, which is where there is a wider general need identified or can be foreseen in the forthcoming period, which the plan should then properly prepare for.
Gotcha. I think, thank you very much. That's very clear. What I would suggest, and I've written down based on those points, if looking at what we've been talking about, the distinction between potential MM35 and MM7, the former being about new policy LP6A, the latter being about local plan review. If you look at paragraph 44 of INSP 5B, I asked about the monitoring indicators, and what I would ask the council to consider, given the interaction between a review and potential policy LP6A, is the amount of land that is coming forward under policy LP6A as a possible indicator, as a monitoring indicator in terms of whether or not a local plan review in whole or part. And I think that was an important point made by, not sure who it was it potentially Mr. Best, that I think that MM7, if it does not already, should consider whether there is a need for review in whole or part, as it may be that if there is a particular issue occurring, say, in employment land or indeed in housing, that could be addressed as a partial review or as even a single policy review. That may be a more proportionate and efficient way of doing it. Does that make sense to the council, what I've said there? And is there anything they would like to add at this stage?
No, sir, that's fine. That makes it a lot clearer. Thank you.
Thank you very much, Mrs. Barrett. Now, Mr. Sitch's hand went up and then down, so unless it goes up again, I'm going to move on. It's very helpful for me in terms of understanding the issues, and I will reflect on that during the break. I did want to, I have misled people in my paragraph 43. Does potential MM109? Well, that doesn't exist. Obviously, numerically, it's the one under MM44 in NWBC 20E. That's clear as day, I think. But I was going to ask probably the council, Mrs. Barrett or Mr. Dittman, under paragraphs 42 or 43, what they consider the implications for any changes to permitted development rights for changes between use classes and the flexibility, therefore, that that potentially leads to in terms of NPPF paragraph 21. Does anyone intend to speak to those points? Because I'm conscious we're slightly over 1 o'clock. Does anyone want to speak to paragraphs 42 or 43 of INSP 5B? If not, I might ask simply the council for their view. And I'm aware that particularly in terms of changes to legislation around use classes, the council are considering how that affects various policies by way of main modification. And my indicative view is obviously that a main modification would be required. But okay, so I can't see any hands up. So let me turn to Mrs. Barrett on points 42 and 43 of INSP 5B. If I could just get your view, that would be brilliant.
In terms of 42, sir, LP21 will need some minor word changing because at the moment it talks about retail shop fronts, but of course it's now commercial, business and service. So what we would like to suggest is that instead of it being retail shop frontage, it actually refers to the Class E, which is the commercial, business and service frontages. Because the development control team are quite keen that the elevations of those buildings are still quite important. They may be able to change between and things like that, but so the change of use itself won't need permission, but the external appearance will require permission, and that's what they would still like to have to be controlled.
Okay, well, I mean, that sounds like there are two issues. There's use and there's character and appearance.
Absolutely.
And so that logically makes sense. In terms of how you might approach that, will you? I mean, could you put a potential main modification out on the potential implications of that to LP21 and other policies, and then I'll consider, because I think you're absolutely right that. Setting aside that we're going under the 2012 MPPF, that applies. That's a fairly hard thing that applies through planning practice, so it would need to be addressed. So I think you're right to address it, and if I can see what you're proposing, that would be fantastic.
Yes, so we're preparing a paper because LP12 is affected by the use classes as well, because that refers to B1A, which is of course now Class E, but B2 and B8 are still there, so it would have to just refer to the Class E2, Class E, sorry, and also LP33 as well. I think there's some changes there in that one. Yeah. Oh, yeah. So, yeah. Sorry, I've got them.
No, you got the information coming in from all directions.
Yes. Yeah. So, but yes, it's the LP12, LP21, and LP33 are probably the three main changes that we've found so far.
Fantastic. Mr. Dittman, did you want to come in on that point, or have you talked in the background to Mrs. Barrett?
No, sir, it's okay. It was whether we'd already forwarded some information to you. That would have been early this morning, but it may not have gone out yet, because I know we are actively working on this, particularly with obviously RTC colleagues, because there are innumerable implications in terms of how it affects not just the retail frontages, which are now commercially, but also whether or not town centres and neighbourhood centres per se are relevant factors as well, and how they apply.
Yeah, sure. And I suppose what I would say is, as and when you do, either you produce a note or come up with some potential main modifications in line with what you said, I would put them on the examination website so that they can be publicly available. There is the opportunity to comment on any main modifications in, I think it's the afternoon session on Thursday. So if it can be done before then, I'll take a look before then and make any comments. Yeah, okay, but it doesn't look like anyone in this session is intending on commenting on those, which brings me to my last point I had, which was, are the monitoring indicators, this is paragraph 44 of our NSP 5B, are the monitoring indicators related to employment land provision specific, justified and measurable? Now, we've talked in the round, haven't we, about monitoring indicators in terms of potential new policy LP6A. We've talked about MM7, potential MM7, which relates to local plan review. Under this one, I would, there is so if you look at NWBC 20E, page 73, there are a number of monitoring indicators that are set out there. One of which, in terms of particularly relevant in terms of employment land, although we are talking about employment land in hectarage, often in terms of what we've been discussing, one of those is to pick out the floor spaces in terms of different use classes. Now that is simply as a potential monitoring indicator, so there is some fine-grained information of what is occurring in practice. But does anyone here want to make any comment on basically page 73 of NWBC 20E onwards, or otherwise in respect of monitoring indicators related to employment land? Okay. I personally think monitoring is the most fascinating element of the discussion, but there we are. That's just me. Okay, well, I will. I've kept a note of a lot of things. I think I've got 6 or so points coming out of today. What I'll do is I will go through them in a sort of administrative session this afternoon. But I think Mr. Rouse is going to take me up on my preemptively. I was going to say, if there is anything I haven't enabled anyone to say, now is the time. So, Mr. Rouse.
Well, I had to come in, so as you invited it. So it was. I've not, to be honest, really studied this in huge detail, but it was just a quick point that under the LP6A monitoring, it obviously relates just to the evidence of immediate unmet need. And just thinking about what we were saying earlier about cross-referencing to the MM7 and the need for plan review, the thing that needs to be monitored is not just the immediate unmet need, because the immediate unmet need will not be satisfied by a plan review. That will be lost because the plan review will take too long, as this process eloquently evidences. So I think the monitoring requirement there in relation to employment land or strategic employment land ought to be something other than immediate. I think it ought to be a more general, longer term forecast requirement.
Okay, I see the logic of that. Can I ask? Can I put that to the council?
LP6A, sir, says to report the trend. That's on page 74. So would that not actually be the same?
Let me just go there. I think Mr. Rouse's point went to the column 3. So amount of employment land provision delivered by use class by hectare and square metre relative to evidence of immediate unmet need. I can see that there's a bit of a sort of logical tension, as Mr. Rouse mentioned, in terms of looking at immediate unmet need, which by definition is immediate, whereas there may be indicators there as to what the future supply is. The future demand is. I don't know.
Excuse me, sir. The version that I have in column 3 just says amount of housing, employment and traveller provision coming forward relative to minimum requirements in line with anticipated delivery rates. And then it says employment land delivered by use class and by hectares and square metres. I can't see anything that says immediate need. Unless I've got a different version.
Well, I think we're going to, as I said earlier, we're going to come across this. But what I will do is I will just take the version I have a look through it. Because what I can see reference to immediate need being there, although you are right that in the version that I see NWBC 20E on the website, it does just simply say report trend. But I think I will need to just reflect briefly on the point Mr. Rouse has made, that if the monitoring is simply reflecting what the immediate need is, that doesn't do anything effectively to put the planning on a positive, sort of positively prepared basis to look forward. It just responds. So I will have a look at that just to make sure that we've got the correct version and all the various bits and pieces that we've been talking about marry up. So that's one that I will have a look at. Thank you. So as Mr. Rouse did, if there are Any other points that anyone wants to make that I've not enabled you to make? I hope you found the discussion useful. I certainly have, and I have given everyone fair opportunity to comment. Any further comments, or else I will adjourn. And I'm afraid we have a relatively short lunch until we're back at 2 to look at environmental considerations and heritage. So unless there's anything else, thank you very much for your contributions, very useful. I will adjourn and we'll come back at 2. Thank you. You can press